Republic Act No. 386. An act to ordain and institute the Civil Code of the Philippines. Preliminary title. Chapter 1. Effect and application of laws. Article 1. This act shall be known as the Civil Code of the Philippines, N. Article 2. Laws shall take effect after 15 days following the completion of their publication in the Official Gazette, unless it is otherwise provided. This code shall take effect 1 year after such publication. 1a. Article 3. Ignorance of the law excuses no one from compliance therewith. 2. Article 4. Laws shall have no retroactive effect, unless the contrary is provided. 3. Article 5. Acts executed against the provisions of mandatory or prohibitory laws shall be void, except when the law itself authorizes their validity. 4a. Article 6. Rights may be waived, unless the waiver is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. 4a. Article 7. Laws are repealed only by subsequent ones, and their violation or non-observance shall not be excused by disuse, or custom or practice to the contrary. When the courts declared a law to be inconsistent with the Constitution, the former shall be void and the latter shall govern. Administrative or executive acts, orders and regulations shall be valid only when they are not contrary to the laws or the Constitution. 5a. Article 8. Judicial decisions applying or interpreting the laws or the Constitution shall form a part of the legal system of the Philippines. N. Article 9. No judge or court shall decline to render judgment by reason of the silence, obscurity or insufficiency of the laws. 6. Article 10. In case of doubt in the interpretation or application of laws, it is presumed that the law-making body intended right and justice to prevail. N. Article 11. Customs which are contrary to law, public order or public policy shall not be countenanced. N. Article 12. A custom must be proved as a fact, according to the rules of evidence. N. Article 13. When the laws speak of years, months, days or nights, it shall be understood that years are of 365 days each, months, of 30 days, days, of 24 hours, and nights from sunset to sunrise. If months are designated by their name, they shall be computed by the number of days which they respectively have. In computing a period, the first day shall be excluded, and the last day included. 7a. Article 14. Penal laws and those of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations. 8a. Article 15. Laws relating to family rights and duties, or to the status, condition and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. 9a. Article 16. Real property as well as personal property is subject to the law of the country where it is stipulated. However, intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found. 10a. Article 17. The forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by Philippine laws shall be observed in their execution. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy and good customs, shall not be rendered ineffective by laws or judgments promulgated, or by determinations or conventions agreed upon in a foreign country. 11a. Article 18. In matters which are governed by the Code of Commerce and special laws, their deficiency shall be supplied by the provisions of this Code. 16a. Chapter 2. Human Relations. N. Article 19. Every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. Article 20. Every person who, contrary to law, willfully or negligently causes damage to another, shall indemnify the latter for the same. Article 21. Any person who willfully causes loss or injury to another in manner that is contrary to morals, good customs or public policy shall compensate the latter for the damage. Article 22. Every person who through an act of performance by another, or any other means, acquires or comes into possession of something at the expense of the latter without just or legal ground, shall return the same to him. Article 23. Even when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter shall be liable for indemnity if through the act or event he was benefited. Article 24. In all contractual, property or other relations, when one of the parties is at a disadvantage on account of his moral dependence, ignorance, indigence, mental weakness, tender age or other handicap, the courts must be vigilant for his protection. Article 25. Thoughtless extravagance in expenses for pleasure or display during a period of acute public want or emergency may be stopped by order of the courts at the instance of any government or private charitable institution. Article 26. Every person shall respect the dignity, personality, privacy and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention and other relief. 1. Prying into the privacy of another's residence. 2. Meddling with or disturbing the private life or family relations of another. 3. Intriguing to cause another to be alienated from his friends. 4. Vexing or humiliating another on account of his religious beliefs, lowly station in life, place of birth, physical defect, or other personal condition. Article 27. Any person suffering material or moral loss because a public servant or employee refuses or neglects without just cause to perform his official duty may file an action for damages and other relief against the latter, without prejudice to any disciplinary administrative action that may be taken. Article 28. Unfair competition in agricultural, commercial or industrial enterprises or in labor through the use of force, intimidation, deceit, machination or any other unjust, oppressive or high-handed method shall give rise to a right of action by the person who thereby suffers damage. Article 29. When the accused in a criminal prosecution is acquitted on the ground that his guilt has not been proved beyond reasonable doubt, a civil action for damages for the same act or omission may be instituted. Such action requires only a preponderance of evidence. Upon motion of the defendant, the court may require the plaintiff to file a bond to answer for damages in case the complaint should be found to be malicious. If in a criminal case the judgment of acquittal is based upon reasonable doubt, the court shall so declare. In the absence of any declaration to that effect, it may be inferred from the text of the decision whether or not the acquittal is due to that ground. Article 30. When a separate civil action is brought to demand civil liability arising from a criminal offense, and no criminal proceedings are instituted during the pendency of the civil case. A preponderance of evidence shall likewise be sufficient to prove the act complained of. Article 31. When the civil action is based on an obligation not arising from the act or omission complained of as a felony, such civil action may proceed independently of the criminal proceedings and regardless of the result of the latter. Article 32. Any public officer or employee, or any private individual, who directly or indirectly obstructs, defeats, violates or in any manner impedes or impairs any of the following rights and liberties of another person shall be liable to the latter for damages. 1. Freedom of religion. 2. Freedom of speech. 3. Freedom to write for the press or to maintain a periodical publication. 4. Freedom from arbitrary or illegal detention. 5. Freedom of suffrage. 6. The right against deprivation of property without due process of law. 7. The right to a just compensation when private property is taken for public use. 8. The right to the equal protection of the laws. 9. The right to be secure in one's person, house, papers, and effects against unreasonable searches and seizures. 10. The liberty of abode and of changing the same. 11. The privacy of communication and correspondence. 12. The right to become a member of associations or societies for purposes not contrary to law. 13. The right to take part in a peaceable assembly to petition the government for redress of grievances. 14. The right to be free from involuntary servitude in any form. 15. The right of the accused against excessive bail. 16. The right of the accused to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witness in his behalf. 17. Freedom from being compelled to be a witness against oneself, or from being forced to confess guilt, or from being induced by a promise of immunity or reward to make such confession, except when the person confessing becomes a state witness. 18. Freedom from excessive fines, or cruel and unusual punishment, unless the same is imposed or inflicted in accordance with a statute which has not been judicially declared unconstitutional. And 19. Freedom of access to the courts in any of the cases referred to in this article, whether or not the defendant's act or omission constitutes a criminal offense. The aggrieved party has a right to commence an entirely separate and distinct civil action for damages, and for other relief. Such civil action shall proceed independently of any criminal prosecution, if the latter be instituted, and may be proved by a preponderance of evidence. The indemnity shall include moral damages. Exemplary damages may also be adjudicated. The responsibility herein set forth is not demandable from a judge unless his act or omission constitutes a violation of the penal code or other penal statute. Article 33. In cases of defamation, fraud, and physical injuries, a civil action for damages, entirely separate and distinct from the criminal action, may be brought by the injured party. Such civil action shall proceed independently of the criminal prosecution, and shall require only a preponderance of evidence. Article 34. When a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be primarily liable for damages, and the city or municipality shall be subsidiarily responsible therefor. The civil action herein recognized shall be independent of any criminal proceedings, and a preponderance of evidence shall suffice to support such action. Article 35. When a person, claiming to be injured by a criminal offense, charges another with the same, for which no independent civil action is granted in this code or any special law. But the justice of the peace finds no reasonable grounds to believe that a crime has been committed, or the prosecuting attorney refuses or fails to institute criminal proceedings. The complainant may bring a civil action for damages against the alleged offender. Such civil action may be supported by a preponderance of evidence. Upon the defendant's motion, the court may require the plaintiff to file a bond to indemnify the defendant in case the complaint should be found to be malicious. If during the pendency of the civil action, an information should be presented by the prosecuting attorney, the civil action shall be suspended until the termination of the criminal proceedings. Article 36. Prejudicial questions, which must be decided before any criminal prosecution may be instituted or may proceed, shall be governed by rules of court which the Supreme Court shall promulgate and which shall not be in conflict with the provisions of this code. Book 1. Persons. Title I. Civil Personality. Chapter 1. General Provisions. Article 37. Juridical capacity, which is the fitness to be the subject of legal relations, is inherent in every natural person and is lost only through death. Capacity to act, which is the power to do acts with legal effect, is acquired and may be lost. N. Article 38. Minority, insanity or imbecility, the state of being a deaf-mute. Prodigality and civil interdiction are mere restrictions on capacity to act, and do not exempt the incapacitated person from certain obligations, as when the latter arise from his acts or from property relations, such as easements. 32a. Article 39. The following circumstances, among others, modify or limit capacity to act: age, insanity, imbecility, the state of being a deaf-mute, penalty, prodigality, family relations, alienage, absence, insolvency and trusteeship. The consequences of these circumstances are governed in this code, other codes, the rules of court, and in special laws. Capacity to act is not limited on account of religious belief or political opinion. A married woman, 21 years of age or over, is qualified for all acts of civil life, except in cases specified by law. N. Chapter 2. Natural persons. Article 40. Birth determines personality, but the conceived child shall be considered born for all purposes that are favorable to it, provided it be born later with the conditions specified in the following article. 29a. Article 41. For civil purposes, the fetus is considered born if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. 30a. Article 42. Civil personality is extinguished by death. The effect of death upon the rights and obligations of the deceased is determined by law, by contract and by will. 32a. Article 43. If there is a doubt, as between two or more persons who are called to succeed each other, as to which of them died first, whoever alleges the death of one prior to the other, shall prove the same. In the absence of proof, it is presumed that they died at the same time and there shall be no transmission of rights from one to the other. 33. Chapter 3. Juridical persons. Article 44. The following are juridical persons. 1. The state and its political subdivisions. 2. Other corporations, institutions and entities for public interest or purpose created by law. Their personality begins as soon as they have been constituted according to law. 3. Corporations, partnerships and associations for private interest or purpose, to which the Law grants a juridical personality, separate and distinct from that of each shareholder, partner or member. 35a. Article 45. Juridical persons mentioned in Nos. 1 and 2 of the preceding article are governed by the laws creating or recognizing them. Private corporations are regulated by laws of general application on the subject. Partnerships and associations for private interest or purpose are governed by the provisions of this code concerning partnerships. 36 and 37a. Article 46. Juridical persons may acquire and possess property of all kinds, as well as incur obligations and bring civil or criminal actions, in conformity with the laws and regulations of their organization. 38a. Article 47. Upon the dissolution of corporations, institutions and other entities for public interest or purpose mentioned in No. 2 of Article 44, their property and other assets shall be disposed of in pursuance of law or the charter creating them. If nothing has been specified on this point, the property and other assets shall be applied to similar purposes for the benefit of the region, province, city, or municipality which during the existence of the institution derived the principal benefits from the same. 39a. Title II. Citizenship and Domicile. Article 48. The following are citizens of the Philippines. 1. Those who were citizens of the Philippines at the time of the adoption of the Constitution of the Philippines. 2. Those born in the Philippines of foreign parents who, before the adoption of said Constitution, had been elected to public office in the Philippines. 3. Those whose fathers are citizens of the Philippines. 4. Those whose mothers are citizens of the Philippines and, upon reaching the age of majority, elect Philippine citizenship. 5. Those who are naturalized in accordance with law. N. Article 49. Naturalization and the loss and reacquisition of citizenship of the Philippines are governed by special laws. N. Article 50. For the exercise of civil rights and the fulfillment of civil obligations, the domicile of natural persons is the place of their habitual residence. 40a. Article 51. When the law creating or recognizing them, or any other provision does not fix the domicile of juridical persons, the same shall be understood to be the place where their legal representation is established or where they exercise their principal functions. 41a. Title III. Marriage. Chapter 1. Requisites of marriage. Article 52. Marriage is not a mere contract but an inviolable social institution. Its nature, consequences and incidents are governed by law and not subject to stipulation, except that the marriage settlements may to a certain extent fix the property relations during the marriage. N. Article 53. No marriage shall be solemnized unless all these requisites are complied with. 1. Legal capacity of the contracting parties. 2. Their consent freely given. 3. Authority of the person performing the marriage, and 4. A marriage license, except in a marriage of exceptional character. Sec. 1a, Art. 3613. Article 54. Any male of the age of 16 years or upwards, and any female of the age of 14 years or upwards, not under any of the impediments mentioned in Articles 80 to 84, may contract marriage. 2. Article 55. No particular form for the ceremony of marriage is required, but the parties with legal capacity to contract marriage must declare, in the presence of the person solemnizing the marriage and of 2 witnesses of legal age, that they take each other as husband and wife. This declaration shall be set forth in an instrument in triplicate, signed by signature or mark by the contracting parties and said 2 witnesses and attested by the person solemnizing the marriage. In case of a marriage on the point of death, when the dying party, being physically unable, cannot sign the instrument by signature or mark, it shall be sufficient for one of the witnesses to the marriage to sign in his name, which fact shall be attested by the minister. Solemnizing the marriage. 3. Article 56. Marriage may be solemnized by 1. The Chief Justice and Associate Justices of the Supreme Court. 2. The Presiding Justice and the Justices of the Court of Appeals. 3. Judges of the Courts of First Instance. 4. Mayors of cities and municipalities. 5. Municipal judges and justices of the peace. 6. Priests, rabbis, ministers of the gospel of any denomination, church, religion or sect, duly registered, as provided in Article 92, and 7. Ship captains, airplane chiefs, military commanders, and consuls and vice-consuls in special cases provided in Articles 74 and 75. 4a. Article 57. The marriage shall be solemnized publicly in the office of the judge in open court, or of the mayor, or in the church, chapel or temple, as the case may be, and not elsewhere, except in cases of marriages contracted on the point of death or in remote places in accordance with Article 72 of this Code, or in case of marriage referred to in Article 76, or when one of the parents or the guardian of the female or the latter herself of over 18 years of age requested in writing, in which cases the marriage may be solemnized at a house or place designated by said parent or guardian of the female or by the latter herself in a sworn statement to that effect. 5a. Article 58. Save marriages of an exceptional character authorized in Chapter 2 of this title, but not those under Article 75, no marriage shall be solemnized without a license first being issued by the local civil registrar of the municipality where either contracting party habitually resides. 7a. Article 59. The local civil registrar shall issue the proper license if each of the contracting parties swears separately before him or before any public official authorized to administer oaths to an application in writing setting forth that such party has the necessary qualifications for contracting marriage. The applicants, their parents or guardians shall not be required to exhibit their residence certificates in any formality in connection with the securing of the marriage license. Such application shall, insofar as possible, contain the following data: 1. Full name of the contracting party. 2. Place of birth. 3. Age, date of birth. 4. Civil status, single, widow or widower, or divorced. 5. If divorced, how and when the previous marriage was dissolved. 6. Present residence. 7. Degree of relationship of the contracting parties. 8. Full name of the father. 9. Residence of the father. 10. Full name of the mother. 11. Residence of the mother. 12. Full name and residence of the guardian or person having charge, in case the contracting party has neither father nor mother and is under the age of 20 years, if a male, or 18 years if a female. 7a. Article 60. The local civil registrar, upon receiving such application, shall require the exhibition of the original baptismal or birth certificates of the contracting parties or copies of such documents duly attested by the persons having custody of the originals. These certificates or certified copies of the documents required by this article need not to be sworn to and shall be exempt from the documentary stamp tax. The signature and official title of the person issuing the certificate shall be sufficient proof of its authenticity. If either of the contracting parties is unable to produce his baptismal or birth certificate, or a certified copy of either because of the destruction or loss of the original, or if it is shown by an affidavit of such party or of any other person that such baptismal or birth certificate has not yet been received, though the same has been requested of the person having custody thereof at least 15 days prior to the date of the application. Such party may furnish in lieu thereof his residence certificate for the current year or any previous years, to show the age stated in his application, or, in the absence thereof, an instrument drawn up and sworn to before the local civil registrar concerned or any public official authorized to solemnize marriage. Such instrument shall contain the sworn declaration of 2 witnesses, of lawful age, of either sex, setting forth the full name, profession, and residence of such contracting party and of his or her parents, if known, and the place and date of birth of such party. The nearest of kin of the contracting parties shall be preferred as witnesses, and in their default, persons well known in the province or the locality for their honesty and good repute. The exhibition of baptismal or birth certificates shall not be required if the parents of the contracting parties appear personally before the local civil registrar concerned and swear to the correctness of the lawful age of said parties, as stated in the application, or when the local civil registrar shall, by merely looking at the applicants upon their personally appearing before him, be convinced that either or both of them have the required age. 8a. Article 61. In case either of the contracting parties is a widowed or divorced person, the same shall be required to furnish, instead of the baptismal her birth certificate required in the last preceding article, the death certificate of the deceased spouse or the decree of the divorce court, as the case may be. In case the death certificate cannot be found, the party shall make an affidavit setting forth this circumstance and his or her actual civil status and the name and the date of the death of the deceased spouse. In case either or both of the contracting parties, being neither widowed nor divorced, are less than 20 years of age as regards the male and less than 18 years as regards the female, they shall, in addition to the requirements of the preceding articles, exhibit to the local civil registrar the consent to their marriage, of their father, mother or guardian, or persons having legal charge of them, in the order mentioned. Such consent shall be in writing, under oath taken with the appearance of the interested parties, before the proper local civil registrar, or in the form of an affidavit made in the presence of 2 witnesses and attested before any official authorized by law to administer oaths. 9a. Article 62. Males above 20 but under 25 years of age, or females above 18 but under 23 years of age, shall be obliged to ask their parents or guardian for advice upon the intended marriage. If they do not obtain such advice, or if it be unfavorable, the marriage shall not take place till after 3 months following the completion of the publication of the application for marriage license. A sworn statement by the contracting parties to the effect that such advice has been sought, together with the written advice given, if any, shall accompany the application for marriage license. Should the parents or guardian refuse to give any advice, this fact shall be stated in the sworn declaration. N. Article 63. The local civil registrar shall post during 10 consecutive days at the main door of the building where he has his office a notice, the location of which shall not be changed once it has been placed, setting forth the full names and domiciles of the applicants for a marriage license and other information given in the application. This notice shall request all persons having knowledge of any impediment to the marriage to advise the local registrar thereof. The license shall be issued after the completion of the publication, unless a local civil registrar receives information upon any alleged impediment to the marriage. 10a. Article 64. Upon being advised of any alleged impediment to the marriage, the local civil registrar shall forthwith make an investigation, examining persons under oath. If he is convicted that there is an impediment to the marriage, it shall be his duty to withhold the marriage license, unless he is otherwise ordered by a competent court. N. Article 65. The local civil registrar shall demand the previous payment of fees required by law or regulations for each license issued. No other sum shall be collected, in the nature of a fee or tax of any kind, for the issuance of a marriage license. Marriage licenses shall be issued free of charge to indigent parties, when both male and female do not each own assessed real property in excess of 500 pesos, a fact certified to, without cost, by the provincial treasurer, or in the absence thereof by a statement duly sworn to by the contracting parties before the local civil registrar. The license shall be valid in any part of the Philippines, but it shall be good for no more than 120 days from the date on which it is issued, and shall be deemed cancelled at the expiration of said period if the interested parties have not made use of it. 11a. Article 66. When either or both of the contracting parties are citizens or subjects of a foreign country, it shall be necessary, before a marriage license can be obtained, to provide themselves with a certificate of legal capacity to contract marriage, to be issued by their respective diplomatic or consular officials. 13a. Article 67. The marriage certificate in which the contracting parties shall state that they take each other as husband and wife, shall also contain 1. The full names and domiciles of the contracting parties. 2. The age of each. 3. A statement that the proper marriage license has been issued according to law and that the contracting parties have the consent of their parents in case the male is under 20 or the female under 18 years of age, and 4. A statement that the guardian or parent has been informed of the marriage, if the male is between the ages of 20 and 25 years, and the female between 18 and 23 years of age. 15a. Article 68. It shall be the duty of the person solemnizing the marriage to furnish to either of the contracting parties one of the 3 copies of the marriage contract referred to in Article 55, and to send another copy of the document not later than 15 days after the marriage took place to the local civil registrar concerned, whose duty it shall be to issue the proper receipt to any person sending a marriage contract solemnized by him, including marriages of an exceptional character. The official, priest, or minister solemnizing the marriage shall retain the 3rd copy of the marriage contract, the marriage license and the affidavit of the interested party regarding the solemnization of the marriage in a place other than those mentioned in Article 57 if there be any such affidavit in the files that he must keep. 16a. Article 69. It shall be the duty of the local civil registrar to prepare the documents required by this title, and to administer oaths to all interested parties without any charge in both cases. The documents and affidavits filed in connection with applications for marriage licenses shall be exempt from the documentary stamp tax. 17a. Article 70. The local civil registrar concerned shall enter all applications for marriage licenses filed with him in a register book, strictly in the order in which the same shall be received. He shall enter in said register the names of the applicants, the date on which the marriage license was issued, and such other data as may be necessary. 18a. Article 71. All marriages performed outside the Philippines in accordance with the laws in force in the country where they were performed, and valid there as such, shall also be valid in this country, except bigamous polygamous or incestuous marriages as determined by Philippine Law, 19A. Chapter 2. Marriages of exceptional character. Article 72. In case either of the contracting parties is on the point of death or the female has her habitual residence at a place more than 15 kilometers distant from the municipal building and there is no communication by railroad or by provincial or local highways between the former and the latter, the marriage may be solemnized without necessity of a marriage license, but in such cases the official, priest, or minister solemnizing it shall state in an affidavit made before the local civil registrar or any person authorized by law to administer oaths that the marriage was performed in articulo mortis or at a place more than 15 kilometers distant from the municipal building concerned, in which latter case he shall give the name of the barrio where the marriage was solemnized. The person who solemnized the marriage shall also state, in either case, that he took the necessary steps to ascertain the ages and relationship of the contracting parties and that there was in his opinion no legal impediment to the marriage at the time that it was solemnized. 20. Article 73. The original of the affidavit required in the last preceding article, together with a copy of the marriage contract, shall be sent by the person solemnizing the marriage to the local civil registrar of the municipality where it was performed within the period of 30 days after the performance of the marriage. The local civil registrar shall, however, before filing the papers, require the payment into the municipal treasury of the legal fees required in Article 65. 21. Article 74. A marriage in articulo mortis may also be solemnized by the captain of a ship or chief of an airplane during a voyage, or by the commanding officer of a military unit, in the absence of a chaplain, during war. The duties mentioned in the two preceding articles shall be complied with by the ship captain, airplane chief or commanding officer. N. Article 75. Marriages between Filipino citizens abroad may be solemnized by consuls and vice-consuls of the Republic of the Philippines. The duties of the local civil registrar and of a judge or justice of the peace or mayor with regard to the celebration of marriage shall be performed by such consuls and vice-consuls. N. Article 76. No marriage license shall be necessary when a man and a woman who have attained the age of majority and who, being unmarried, have lived together as husband and wife for at least 5 years, desire to marry each other. The contracting parties shall state the foregoing facts in an affidavit before any person authorized by law to administer oaths. The official, priest or minister who solemnized the marriage shall also state in an affidavit that he took steps to ascertain the ages and other qualifications of the contracting parties and that he found no legal impediment to the marriage. N. Article 77. In case two persons married in accordance with law desire to ratify their union in conformity with the regulations, rites, or practices of any church, sect, or religion, it shall no longer be necessary to comply with the requirements of Chapter 1 of this title, and any ratification so made shall merely be considered as a purely religious ceremony. 23. Article 78. Marriages between Mohammedans or pagans who live in the non-Christian provinces may be performed in accordance with their customs, rites or practices. No marriage license or formal requisites shall be necessary, nor shall the person solemnizing these marriages be obliged to comply with Article 92. However, 20 years after approval of this code, all marriages performed between Mohammedans or pagans shall be solemnized in accordance with the provisions of this code. but the President of the Philippines, upon recommendation of the Secretary of the Interior, may at any time before the expiration of said period, by proclamation, make any of said provisions applicable to the Mohammedan and non-Christian inhabitants of any of the non-Christian provinces. 25a. Article 79. Mixed marriages between a Christian male and a Mohammedan or pagan female shall be governed by the general provision of this title and not by those of the last preceding article. But mixed marriages between a Mohammedan or pagan male and a Christian female may be performed under the provisions of the last preceding article if so desired by the contracting parties. Subject, however, in the latter case to the provisions of the second paragraph of said article. 26. Chapter 3. Void and voidable marriages. Article 80. The following marriages shall be void from the beginning. 1. Those contracted under the ages of 16 and 14 years by the male and female, respectively, even with the consent of the parents. 2. Those solemnized by any person not legally authorized to perform marriages. 3. Those solemnized without a marriage license, save marriages of exceptional character. 4. Bigamous or polygamous marriages not falling under Article 83, Number 2. 5. Incestuous marriages mentioned in Article 81. 6. Those where one or both contracting parties have been found guilty of the killing of the spouse of either of them. 7. Those between step-brothers and step-sisters and other marriages specified in Article 82. N. Article 81. Marriages between the following are incestuous and void from their performance, whether the relationship between the parties be legitimate or illegitimate. 1. Between ascendants and descendants of any degree. 2. Between brothers and sisters, whether of the full or half-blood. 3. Between collateral relatives by blood within the fourth civil degree. 28a. Article 82. The following marriages shall also be void from the beginning. 1. Between stepfathers and stepdaughters, and stepmothers and stepsons. 2. Between the adopting father or mother and the adopted. Between the latter and the surviving spouse of the former. And between the former and the surviving spouse of the latter. 3. Between the legitimate children of the adopter and the adopted. 28a. Article 83. Any marriage subsequently contracted by any person during the lifetime of the first spouse of such person with any person other than such first spouse shall be illegal and void from its performance, unless 1. The first marriage was annulled or dissolved, or 2. The first spouse had been absent for 7 consecutive years at the time of the second marriage without the spouse present having news of the absentee being alive, or if the absentee, though he has been absent for less than 7 years, is generally considered as dead and believed to be so by the spouse present at the time of contracting such subsequent marriage, or if the absentee is presumed dead according to Articles 390 and 391. The marriage so contracted shall be valid in any of the 3 cases until declared null and void by a competent court. 29a. Article 84. No marriage license shall be issued to a widow till after 300 days following the death of her husband, unless in the meantime she has given birth to a child. N. Article 85. A marriage may be annulled for any of the following causes existing at the time of the marriage. 1. That the party in whose behalf it is sought to have the marriage annulled was between the ages of 16 and 20 years, if male, or between the ages of 14 and 18 years, if female, and the marriage was solemnized without the consent of the parent, guardian or person having authority over the party, unless after attaining the ages of 20 or 18 years, as the case may be, such party freely cohabited with the other and both lived together as husband and wife. 2. In a subsequent marriage under Article 83, Number 2, that the former husband or wife believed to be dead was in fact living and the marriage with such former husband or wife was then in force. 3. That either party was of unsound mind, unless such party, after coming to reason, freely cohabited with the other as husband or wife. 4. That the consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as her husband or his wife, as the case may be. 5. That the consent of either party was obtained by force or intimidation, unless the violence or threat having disappeared, such party afterwards freely cohabited with the other as her husband or his wife, as the case may be. 6. That either party was, at the time of marriage, physically incapable of entering into the married state, and such incapacity continues, and appears to be incurable. 30a. Article 86. Any of the following circumstances shall constitute fraud referred to in Number 4 of the preceding article. 1. Misrepresentation as to the identity of one of the contracting parties. 2. Non-disclosure of the previous conviction of the other party of a crime involving moral turpitude, and the penalty imposed was imprisonment for 2 years or more. 3. Concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband. No other misrepresentation or deceit as to character, rank, fortune or chastity shall constitute such fraud as will give grounds for action for the annulment of marriage. N. Article 87. The action for annulment of marriage must be commenced by the parties and within the periods as follows. 1. For causes mentioned in Number 1 of Article 85, by the party whose parent or guardian did not give his or her consent, within 4 years after attaining the age of 20 or 18 years, as the case may be, or by the parent or guardian or person having legal charge, at any time before such party has arrived at the age of 20 or 18 years. 2. For causes mentioned in Number 2 of Article 85 by the spouse who has been absent during his or her lifetime, or by either spouse of the subsequent marriage during the lifetime of the other. 3. For causes mentioned in Number 3 of Article 85 by the same spouse, who had no knowledge of the other's insanity, or by any relative or guardian of the party of unsound mind, at any time before the death of either party. 4. For causes mentioned in Number 4, by the injured party, within 4 years after the discovery of the fraud. 5. For causes mentioned in Number 5, by the injured party, within 4 years from the time the force or intimidation ceased. 6. For causes mentioned in Number 6, by the injured party, within 8 years after the marriage. 31a. Article 88. No judgment annulling a marriage shall be promulgated upon a stipulation of facts, or by confession of judgment. In case of non-appearance of the defendant, the provisions of Article 101, Paragraph 2, shall be observed. N. Article 89. Children conceived or born of marriages which are void from the beginning shall have the same status, rights and obligations as acknowledged natural children, and are called natural children by legal fiction. Children conceived of voidable marriages before the decree of annulment shall be considered as legitimate, and children conceived thereafter shall have the same status, rights and obligations as acknowledged natural children, and are also called natural children by legal fiction. N. Article 90. When a marriage is annulled, the court shall award the custody of the children as it may deem best, and make provision for their education and support. Attorneys' fees and expenses incurred in the litigation shall be charged to the conjugal partnership. property, unless the action fails. 33a. Article 91. Damages may be awarded in the following cases when the marriage is judicially annulled or declared void from the beginning. 1. If there has been fraud, force or intimidation in obtaining the consent of one of the contracting parties. 2. If either party was, at the time of the marriage, physically incapable of entering into the married state, and the other party was unaware thereof. 3. If the person solemnizing the marriage was not legally authorized to perform marriages, and that fact was known to one of the contracting parties, but he or she concealed it from the other. 4. If a bigamous or polygamous marriage was celebrated, and the impediment was concealed from the plaintiff by the party disqualified. 5. If in an incestuous marriage, or a marriage between a stepbrother and a stepsister or other marriage prohibited by Article 82, the relationship was known to only one of the contracting parties but was not disclosed to the other. 6. If one party was insane and the other was aware thereof at the time of the marriage. N. Chapter 4. Authority to solemnize marriages. Article 92. Every priest, or minister, or rabbi authorized by his denomination, church, sect, or religion to solemnize marriage shall send to the proper government office a sworn statement setting forth his full name and domicile, and that he is authorized by his denomination, church, sect, or religion to solemnize marriage, attaching to said statement a certified copy of his appointment. The director of the proper government office, upon receiving such sworn statement containing the information required, and being satisfied that the denomination, church, sect, or religion of the applicant operates in the Philippines, shall record the name of such priest or minister in the suitable register and issue to him an authorization to solemnize marriage. Said priest or minister or rabbi shall be obliged to exhibit his authorization to the contracting parties, to their parents, grandparents, guardians, or persons in charge, demanding the same. No priest or minister not having the required authorization may solemnize marriage. 34a. Article 93. Freedom of religion shall be observed by public officials in the issuance of authorization to solemnize marriages. Consequently, no public official shall attempt to inquire into the truth or validity of any religious doctrine held by the applicant or by his church. N. Article 94. The public official in charge of registration of priests and ministers shall cancel the authorization issued to a bishop, head, priest, rabbi, pastor or minister of the gospel of any denomination, church, sect, or religion, on his own initiative or at the request of any interested party, upon showing that the church, sect or religion whose ministers have been authorized to solemnize marriage is no longer in operation. The cancellation of the authorization granted to a priest, pastor or minister shall likewise be ordered upon the request of the bishop, head, or lawful authorities of the denomination, church, sect or religion to which he belongs. 35a. Article 95. The public official in charge of registration of priests and ministers, with the approval of the proper head of department, is hereby authorized to prepare the necessary forms and to promulgate regulations for the purpose of enforcing the provisions of this title. Said official may also by regulations fix and collect fees for the authorization of priests and ministers to solemnize marriages. 36a. Article 96. The existing laws which punish acts or omissions concerning the marriage license, solemnization of marriage, authority to solemnize marriages, and other acts or omissions relative to the celebration of marriage, shall remain and continue to be in force. N. Title IV. Legal separation. Article 97. A petition for legal separation may be filed. 1. For adultery on the part of the wife and for concubinage on the part of the husband as defined in the Penal Code, or 2. An attempt by one spouse against the life of the other. N. Article 98. In every case the court must take steps before granting the legal separation toward the reconciliation of the spouses, and must be fully satisfied that such reconciliation is highly improbable. N. Article 99. No person shall be entitled to a legal separation who has not resided in the Philippines for 1 year prior to the filing of the petition, unless the cause for the legal separation has taken place within the territory of this Republic. Sect 2A, Act No. 2710. Article 100. The legal separation may be claimed only by the innocent spouse, provided there has been no condonation of or consent to the adultery or concubinage. Where both spouses are offenders, illegal separation cannot be claimed by either of them. Collusion between the parties to obtain legal separation shall cause the dismissal of the petition. 3A, Act No. 2710.